So a lot of people ask, what is it that a judge thinks about when it's determining custody? I mean, you've probably heard best interest of the child, that's the standard, but you may not know what that means. Lawyers and judges, we deal with statutes that sets out the sort of the ground rules for how something will be decided. And then there are cases that interpret those statutes. So in this scenario, how does the statute work in this scenario or in this scenario? Those are the things that case law can be instructive for both lawyers and judges. And the reason I raise that is best interest of the child is one of the things that is in part defined by the statute because it gives us factors that judges look at and that lawyers look at to determine whether something's in a child's best interest. And then there are court cases that tell us more about it too. My best advice, if you're trying to figure out what a judge would look at in your case on parenting and custody, is to talk to a lawyer so you can really talk about your specific situation, because there's just no good general in a vacuum answer. You really need specific legal advice, and you ideally want to talk to someone who knows the courtrooms across Connecticut and how the judges are viewing things across Connecticut, so you can get as educated an opinion as possible on how a judge might view things. The standard for what's in a child's best interest isn't necessarily going to reach the level of parenting that might be your standards. So for example, if your view of what's best for your child doesn't align with your spouse's view about what's best for your child. For example, how much spending money a child should have when they should get a phone, how much freedom they should have when they should need to be home, if they should eat junk food or fast food or not eat junk food or fast food. Courts don't really want to get into what I would call things that are more about parenting choices, and instead is going to be focused more on making sure that your child has quality relationships with both parents, and then allowing both parents to, have some different sets of rules when the child is in one house versus the other. One of the things that we like to talk about is how we construct the parenting plan when we have the opportunity to negotiate it out of court, maybe using professionals who are mental health professionals who really understand child development and things like that. There's a bigger opportunity to create a real intentional plan if you and your spouse are working on it through your lawyers and through your other experts and advisors than there is if you're just sort of throwing things in front of a judge and letting a judge decide, given limited information and limited time to learn about the decision they're making. So if custody and parenting are something that are really concerns for you and you want to make sure that it's a very considered approach, I'd recommend considering things like bringing in other professionals and really thinking about keeping at least that aspect of your divorce in the category of things that you're negotiating and deciding rather than things that you're asking a judge to decide. There are some tips, though, to how to make an agreement that works for your family. You want to really think about the nuances of your family. Every family has them. Do both parents work outside the home? Do they both work in jobs with consistent hours? Is someone starting a new business? Is someone an ER doctor with an unpredictable schedule? Is someone travel a lot for work? These things about your family structure, just like they're true while you're in one home, are also true when you're in two homes. And so when we're putting together a plan that's most likely to work for your family, we really want to think about those things. What are holiday traditions on one side that are very important versus with the other parent's family? So that we can build something that is customized for your family. And I think another thing that can be a really valuable tool if there are areas of disagreement where you and your co-parent have differing views on how something should work, and you're both intending to be the best parents you can possibly be, you just disagree with what form that takes. Well, mental health professionals that have experience in child development and, yes, the divorce process and parenting plans can be a real asset to help you both reach an agreement that you'll know is workable, but that more importantly is really designed to support your children. A lot of people are attracted to mediation as a way to resolve parenting and custody issues that doesn't involve putting these issues in front of a judge. The downsides of putting things in front of a judge with real respect to the judges that are trying to make these decisions is they don't have the benefit of a lot of time or information to work with when they're making decisions. Trials are hectic. There's not infinite time. There's evidentiary rules that governs how information comes in. It's a zero-sum setup, so it can be hard to get nuances in that context. So keeping things out of court where the two of you, with the benefit of your advisors and attorneys, are reaching an agreement is a really good place to address many, many people's custody or parenting plans. Mediation is one of the ways to do that. It can be a great way to keep things out of court and resolve custody. There's flexibility, there's time. You can involve professionals who really understand child development and have proposals about plans that might be best to support children given the circumstances of your family. But don't overlook things like collaborative divorce that offers some of the same benefits of mediation with regard to getting real insights from professionals who work with children and children's development. There are also those tools available even in the context of a traditional litigated divorce. Just because you file a divorce in Connecticut with the court and go through the litigation process doesn't mean that you're not able to use ADR options to resolve things outside of asking a judge to decide. It doesn't mean that at all. So bringing to bear these resources to try and get the very best plan in place for your kids that's workable for you and your spouse, which means it will work for your kids in large part, those are things that are really, really important. And whether it's mediation or resolving things out of court in a litigation or a collaborative divorce, those can be really solid tools to get a nuanced, dialed-in plan for your family. One of the ways that people can get into trouble is making big changes to parenting without a court order. That sounds a little crazy at the beginning, right? If you have two parents post-divorce who are agreeing to make changes to their parenting plan, isn't that a good thing? Yeah, it is a good thing, but you want to make sure that you do it right. So the first step, if you're thinking of making a major change to parenting, and I'm not talking about whether drop-offs at 4 o'clock or 5 o'clock, I'm talking about things like, where does everyone live? Is someone moving to a town that's further away, out of state, out of country? Big changes to parenting, just run them by an attorney before you make them, because what that attorney is going to want to do is look at the original court-ordered plan and see whether that plan accommodates this change, gives you the flexibility to do it without going to court, or whether or not you do need to go to court to make sure that that change is formalized, so that if someone changes their mind down the road, you're not stuck in a situation where you had an agreement, but the formal court order doesn't line up with that agreement. So what I want you to think about is make sure what you're doing is permissible under the agreement as is, or if it's not, that doesn't mean you have to go to court to fight about it, but you will want to formalize the agreement that you're making and probably enter it with the court to make sure that the court is comfortable with it and make it a formal court order so that everything is square, the I's are dotted, the T's are crossed, and you're doing everything that you need to do to live up to and follow the court's orders, even when you're making changes. When parents are divorcing, their priorities often are around making sure that their children make the transition from one home to two homes as healthy and happily as possible. If you would like to talk more about this, please give us a call. We are always here to discuss it.